Federal appeals court in a unanimous decision refusing to reinstate the president's travel ban. The president vowing to fight the ruling, tweeting, "See you in court." Back with me now, Pamela Brown, Mark Preston, Ariane DeVogue, Laura Coates, David Gergen, Alan Dershowitz, Michael Higginbotham, and Paige Pate. Pamela, back to you now. Now that the Ninth Circuit Court has ruled, what happens next?
Well, a couple of things could happen next. As we know, the Department of Justice is looking at this opinion that was released by the Ninth Circuit Court and trying to figure out what the next step is, whether Department of Justice should appeal to en banc, which essentially would ask more judges in the Ninth Circuit, 11 out of the 40 judges in the Ninth Circuit, to review this case. Or another option, of course, would be to appeal to the Supreme Court. Now, as you know, there are 8 justices in the Supreme Court because Justice Scalia's seat hasn't been filled. So if there was a 4-4 split there, that means what the Ninth Circuit Court ruled today, to put this travel ban on hold during the appeals process, would stand. So there really are a number of options. And of course, as we discussed, the administration could go back to the drawing board essentially with this executive order and rework it or start new. So a number of things could happen from here. But as you heard President Trump say today, he insinuated, look, this legal battle will continue and I'll see you in court.
Yeah. Jim Acosta caught up with senior advisor Kellyanne Conway. Listen.
He sees it as what he's always seen it as, which is the statute provides a president, in this case President Trump, with great latitude and authority to protect the citizens and protect the nation's national security. This was not argued on the merits. Now that we'll have an opportunity to argue on the merits, we look forward to doing that. We look forward to prevailing. I think his tweet was perfect when he said, "We'll see you in court."
So, Ariane, the president has made it very clear that he's going to fight this. Do you see the administration taking this to the Supreme Court, and how quickly could that happen?
Well, they're going to have to make a decision. For instance, they could try, as Pamela said, to go en banc. What that means is try to get a larger panel of judges at the Ninth Circuit to look at this. That would mean they would hope that a larger panel might decide differently. If they decide not to do that, that's true. They'd go to the Supreme Court. Justice Anthony Kennedy has jurisdiction over the Ninth Circuit, so what he would do is probably refer it to his colleagues, and they'd look at it pretty quickly. But remember, no court has yet ruled whether this is constitutional or not. Nobody said yes, it's legal, or no, it's not. We're still at that preliminary juncture right now.
Paige, you're shaking your head. Hang on, Paige. Why are you?
I'm absolutely shaking my head. I thought it was too early for the government to take it to the Ninth Circuit. It is way too early for them to take it to the Supreme Court. I would be very surprised if the Supreme Court accepted the case at this point, because as we've pointed out already, we don't even have a decision on the merits. This is all temporary relief. It's a TRO, a preliminary injunction. The last thing the Supreme Court wants to do is review that type of an order. Let it go back to the district court. Let's go ahead and have these arguments. If in the meantime the White House wants to draft a better, perhaps constitutional executive order, let them do that. But it's way too early for the Supreme Court.
Alan Dershowitz?
Look, the Trump administration has a real dilemma. They have a winning argument on the merits, ultimately. This court's decision that this is a Muslim ban will never stand. The Supreme Court will not give weight to the fact that the president during his campaign talked about a Muslim ban, or Rudy Giuliani talked about a Muslim ban. That's just not going to fly in the Supreme Court. The standing argument probably won't fly. It's the most extreme standing argument I have ever seen made. The argument that because you exempt religious minorities establishes a religion is absurd. When the War Refugee Act in 1944 applied only to Jews because they were the victims of Nazi oppression, that was constitutional.
Okay.
The idea that the president can't... So I think they have a very, very hard case. But it's going to take months. And if the president really believes that the security of the country is at stake, then he has to do something now.
Okay.
He can't wait to win this month from now.
Got it. Laura, why do you disagree with that?
I disagree, because the First Amendment Establishment Clause, as you well know, says that essentially the United States is denominationally neutral. We don't prefer, let alone advocate for a particular religion. And there is a clause within the executive order that says that they will give preference to the minority religion in a particular area. Now that in and of itself may...
That's the right thing to do.
That in and of itself, Alan, may inure to the benefit of multiple religions. However, we don't prefer one in our particular Constitution. Therefore, that would be an issue.
You
Well, hold on.
prefer
Let- well,
victims.
what
You
I'm- what
prefer
I'm going to do-
persecuted people, right?
No, I'm going to finish my point and tell you that my preference is that the Supreme Court would prefer that any executive order comply with the Constitution, and as do I. And you know, the idea that it would be absurd that this is the most egregious case of standing issues we've ever seen is a little misleading, given the fact that just last year we had a Texas district court that presumed standing when it came to the Dreamers case, and we are all at a disadvantage in figuring out whether or not the Supreme Court ultimately would have agreed that there was
David?
standing, because only 4-4 said that that didn't allow us to have a full opinion. So we have to be a little bit fair.
Yeah, David Gergen, go ahead.
Yeah, let me just say, Don, I think Alan Dershowitz has a compelling point. The president has said it's urgent that we have more control over our borders. We have national security threats, and so Alan's point about what basically he's calling for is revoke and replace, very similar to what they've been talking about on Obamacare, Republicans. But we know that the president wants to challenge it in court, so that Alan's argument, I think many of us feel the president won't do it on this grounds, but I do think there's an alternative ground. The president could do exactly what he's saying, that is, we're going to go to court on this executive order. In the meantime, what we were calling for in this existing executive order was a pause in order to re-examine our policies with regard to and our vetting processes. So I'm going to use the next few weeks while the courts are, haggling over this. I'm going to use the next few weeks to work with Democrats and come up with a new executive order that will be a long-term executive order, not a pause, but this will be the answer for the long term.
You know, you're talking about
when the courts have gotten
President
through
Trump.
At some point, we're going to put it into play.
You realize you're talking about the
have
Trump
one that's going to
administration,
pass
right?
muster.
Let me be clear, gentlemen. You're absolutely right that the president has the prerogative to decide national security, but that's not without checks and balances. And you're right. There could perhaps be a compelling argument in favor of why we cannot return to the pre-travel ban vetting procedures. However, the responsibility of the court is not to pull those, responsibilities or justifications out of the air. You must present them.
But a new executive order could put in a provision that says you cannot discriminate. We will not discriminate. No one should discriminate on the basis of religion. You could perfect this.
You could do that.
Alan is arguing.
You could do that. However, that did not happen, and that's why to accuse the court of having a bad decision would be a little bit premature, given the fact that the Justice Department failed to make those arguments, to raise those things.
Michael, you've been sitting by patiently. Do you want to add anything to this?
Absolutely. I think what the court has said is that the president has great discretion, particularly in the national security area, and that when Congress authorizes the president to act, the courts will give even more deference. That said, the courts will make the final determination. The courts, there were many cases that were cited by the Ninth Circuit that talked about how even if it's national security, the court will have the final determination on interpreting the Constitution. So it doesn't matter that the president says this is about national security and Congress has authorized it. The court will make that determination. And they made it very clear that if there is discrimination going on, the court will say that is a violation of the Constitution.
All right, that's going to be the last word for now. You all will be back. I'll see you a little bit later on. In the meantime, there's more controversy with the president's Supreme Court pick. We'll discuss that coming up.